The next case is Stirling versus Leelanau County. Council, will you take your places? This is a 15-minute mini oral argument on the application. Ms. Stirling, that means you may reserve some of that time if you don't run out of it, and you have 2 minutes of a free fire zone. You may proceed when you're ready.
Good morning, Your Honors, and may it please the Court. Carla Stirling here on behalf of appellant applicant Mack Stirling. With permission of the Court, I will reserve 3 minutes at the end for rebuttal. And this will be brief, as this case presents the straightforward matter of a Michigan resident and his wife who have lived in their Traverse City home for over 30 years. They had the opportunity to buy 2 investment properties in Utah some years back, which they rented out to third parties and which were properly declared and taxed as rental properties. Stirling's PRE was subsequently denied because he claimed exemptions for those rental properties in Utah, what Utah calls a primary residential exemption. The county has argued that because those exemptions were for a residence, any residence, it is substantially similar to the PRE. We disagree, as MCL 211.7 CC3B plainly and unambiguously lays out the test for substantial similarity, which is whether the exemption claimed is substantially similar to the exemption provided under this section. And I meant to quote that quote, substantially similar to the exemption provided under this section, close quote. The words are substantially similar to the exemption provided under this section. That section specifically states multiple times in 7CC and DD by reference that the PRE applies only to homesteads, defined by statute and reiterated by this court as owner-occupied residences. As the court in Levenfeld specified over a decade ago, the one place an owner has his or her home. The Stirlings never lived in the Utah properties nor claimed to have lived in those properties, let alone called those properties home. Stirling has a home in Michigan and bought a couple rentals in another state. Stirling's not alone. As of July 1st, 2019, Michigan had over 4,629,000 housing units, and over 70% were owner-occupied. That's over 3 million Michiganders who own their home, more if we considered many of the owners are married couples. Those millions of people, including people in this room, should not have to worry about losing their PRE if they buy rental property in another state, regardless of any favorable tax treatment that state grants to rental properties. The people should be able to rely on the plain meaning of the unambiguous language in the statute, which says the PRE is for your home, and your home is your home, the place where you live. Your rental property, where other people live, is not your home, and you shouldn't lose your PRE because of an exemption on your rental property. The tax tribunal got it right, and we ask that this court hold accordingly.
Ms. Stirling, can you help me? I understand your position that, looking at the Utah statute, right, that's B1, sub B1, that you can obtain the exemption in Utah if it's the primary residence of the owner. I think you would say that that is the same as or equal to the Michigan
That particular
exemption.
subsection.
That particular subsection. And then I understand your position to say that sub 2 of that the residential property that is the primary residence of a tenant is not substantially similar. Can you give me an example of what you think would be substantially similar to Michigan's exemption? That could you tell me an example either from another state or a hypothetical statute of how you would describe an exemption in another state that is substantially similar to Michigan's?
Yeah, for example, in Levenfeld, I think there was the Illinois statute there, where the tax rates were very different, and the couple had lived separately, but they used the Illinois residence as their home, and so the Illinois statute, it just applied to the to the owner-occupied property, that would be,
So I get factually, I guess I'm looking for a statute either in existence in another state or even a hypothetical statute of how you would draft where you could say, look, at Michigan says you own it and you occupy it as your residence. And if you have a substantially similar one, what would that look like? I mean, because
Anything
it
that
doesn't have to be an
requires-
exact match. It has to
Right.
be substantially similar.
right, so if it is to do with owner occupancy, beginning and end owner occupancy, then it would be substantially similar. When we add, like, for example, in Utah, when, and I will, let me just back up a little bit, because I did get into parsing out those two subsections in my petition for summary disposition before the tax tribunal, where I essentially argued that you can look at these two as two separate exemptions in Utah, although Utah does have this framework where it terms it primary residential, that essentially for comparison here, what Utah is doing, even though a big, broad category in Utah terms it primary residential, we have these very, very different specific
Different ways
subsections.
to get it. I guess I'm, like, if you were, like, if you're only looking to claim the exemption in Utah, I read the statute as saying you get one exemption. Here's a couple ways that you can meet that, right? It could be you own it and you live in it. It could mean you own it and a tenant lives in it. But if you were in Utah and you owned a house and you also owned a tenant-occupied house, could you claim it for both, or you have to choose one?
No, they're totally independent. You can take an exemption on the property that you own and that you live in, completely separately in Utah. When you have rental property where tenants live, then you can claim multiple exemptions on those properties, totally independently of your owner-occupied residence.
Well, what do we then, doesn't the statute say that the exemption is limited to one primary residence per household?
Well, but then with the exceptions, where there's this whole other category. So if you're talking about,
Okay, I see what you're saying. So you could claim it for your own house, and then you could have 17 houses that you own that are tenant occupied.
which is an important distinction here, that they aren't interchangeable. They are independent of each other.
And I think in Michigan, we have the opposite rule for rental properties, where there is no, we don't have something similar in Michigan for a long-term tenant in a house. Those homes, I believe, are not, they don't get the PRE.
That's correct. The PRE doesn't apply at all to rental property.
All right, so in Utah, you have it, so you could have an owner-occupied property, but they could also be in Utah, take Michigan out of the equation. Someone could have a rental property, they get the exemption, as long as it's a long-term rental, which appears to be a policy position that Utah has to incentivize long-term rentals, I assume. But then that owner could also take the exemption in Utah if they have a principal residence as well.
That's right. And owners of properties in other states could also take that tenant-occupied exemption in Utah. They don't have to be residents of Utah to take advantage of that exemption. In addition,
Can we go back to Justice Kavanaugh's question about either in another state or a proposed statute that would be that would be subject to this substantially similar? Because what I hear you arguing here, although I think that you conceded that this statute is substantially similar, what would be an example of something that is not the exact same, but is substantially similar?
and I wouldn't say that it is substantially similar. I would say that there's a subsection that doesn't apply here that may be similar, but the subsection that does apply here and the statute as a whole is not substantially similar. But I would posit that another exemption that allows for an exemption or credit or deduction for an owner that lives in that property.
But isn't that the exact exact same?
Well,
I'm
there,
trying to-
we can, there are different, there, so, we can have differences in the amount of the exemption. We can have differences in the amount of time required to establish, how long, what constitutes living there or residing there for some period of time. There can also be requirements, differences in the requirements to establish that, what you have to say in your affidavit. There can be all sorts of differences in a statute where it's still substantially similar because it has to do with the owner living there. But when we're
So your
talking.
argument is that it's just, I mean, obviously, you're drilling down to sort of not the big statute as a whole, that's all about these principal residence exemptions or exemptions, period. But it's really just tied to, is the owner taking an exemption in two places as the owner?
That is exactly what the PRE was getting at, and what the prohibition was about, is not to be able to double dip, that you have, I live in Michigan in the summer, and I live in Florida in the winter, and so I take exemptions in both places. That wouldn't be fair, that's not right.
Why wouldn't they use then why would they use substantially similar? If you're not trying to capture, or at least leave open the possibility that, look at, a statute that's not quite the same, and instead of it being the owner living there, they're claiming it because somebody else is living there, you still shouldn't get Michigan. Like, why use substantially similar unless it means something? And I understand you're not arguing with the definition of substantially similar that the Court of Appeals embraced.
Well, what it applies to, I certainly am.
Right, but the idea that largely but not wholly alike.
It doesn't have to be exactly the same, and there can be differences, like we saw in Levenfeld, where they only got a very tiny break. In the other state's exemption wasn't very big.
Well, I don't think
But-
I guess maybe that's a difference, but I'm not finding that as persuasive, the fact that maybe you get a lot less money or a lot less of a cut, in a different state. I think the question is a substantially similar exemption. Doesn't have to be an exact match, owner occupied.
But the owner occupancy goes to the heart of the definition of the PRE. So if we step back so far that it can be anybody's that we expand Michigan's test, which is the exemption provided in MCL 211.7 CC. If we can't recognize what the exemption we're talking about here in that exemption, then it fails.
So what do we do? States have policies all over the board on this, right? Every state is a little different with their statutes. The Court of Appeals opinion obviously makes it pretty easy for Treasury to implement, right? So is Treasury now supposed to do an overlay and a deep dive on every statute per section to see? I'm just like, from a practical standpoint, certainly ease of application is desirable and makes the rule clear to everybody. How should Treasury apply? How would it work?
It would work as it works now, that the burden is on the taxpayer to show whether they claimed an exemption that was substantially similar. So, which we posit is owner occupancy. And so if you're talking about a different property, whether it's industrial, commercial, rental property, when you're audited, your PRE is denied, you have the burden to go show that it wasn't for an owner-occupied residence.
So if you had property in another state and lived there less than half the year, then you could claim the Michigan PRE, and because that's not owner occupied in the other state, then you could claim that in that state as well if it allowed you to do that? Because then we would be getting into a situation, I'm thinking of, and I don't recall exactly what Florida's exemptions are, but if Florida said, hey, all you have to do is live here, 5 months of the year, and you can claim an exemption, and you can rent it out the rest of the time and still get the exemption, that you would be able to claim the exemption in Michigan?
I would say no, because if you're living there, you're using it as your homestead. So that is taking a substantially similar exemption if the owner is living there.
Doesn't matter how long.
I don't remember a specific, time requirement under the Michigan PRE.
Doesn't that just prove the point of as long as it's owner occupied? I mean, isn't that the same as opposed to substantially similar? Like, I'm trying to find what that, I get that you say tenant isn't substantially, tenant occupied isn't, and I don't know if you'd say what's the third one, that under construction or something. But whether you live there for 5 months or 7 months or what have you, I read you as saying it's the same as Michigan. Or are you saying it's substantially the same, even though it's not quite the same because you're doing it for less, for some, like, it's the time period that might be where the give is in substantial similarity?
I think that there could be substantial similarity or overlap in time period, in the amount claimed, possibly other factors, but where you have owner occupancy defined in the PRE doesn't provide, there's no basis, there's just no basis for comparison with the exemption that we're talking about in this situation with rental property, where you can take multiple exemptions for rental property. You don't have to be a resident of that state to take that exemption. You also don't have to be an individual. Holders of that exemption can also be organizations like nursing homes, business entities that own apartment buildings, housing authorities, and others. Where do we find any basis for comparison in the Michigan PRE?
Thank you, Counsel.
Good morning, Your Honors. Zach Larson for Appellee Leelanau County. Madam Chief Justice, and may it please the Court. Michigan property tax law disqualifies a person from claiming a principal residence exemption if they receive or their spouse receives a substantially similar exemption in another state, and the law limits Michiganders to one exemption. The phrase substantially similar exemption does not impose a demanding exactness or require an identical scope between the two states' exemptions. Instead, the legislature wisely provided flexibility to account for differences in state laws, looking only to the general character of each. Here, because Appellant Stirling's wife claimed 2 residential exemptions in Utah, which are exemptions defined by their use as a primary residence, Stirling was correctly disqualified from claiming Michigan's PRE. To hold otherwise would create, both for Utah and other states, whole state exemptions and tax loopholes, and allow the Stirlings in this particular instance to claim 3 similar exemptions. Doing so would also weaken the PRE's disqualifier for many states based on differences in the scope rather than in the character of an exemption. Stirling's primary argument to the contrary has been that the Utah exemption applied to his wife's property is somehow distinct from the Utah exemption applied to owner-occupied property, and it is not. Utah's constitution, its statutes, case law, and regulations all confirm that there is a single residential exemption in Utah. Stirling's view also overly restricts the substantial similarity test by narrowly emphasizing a claimant's factual circumstances rather than the character of an exemption, and it overlooks the statutory text suggesting that Michigan's PRE is also just one exemption. So because his PRE was correctly disqualified, this court should either deny his application or affirm the Court of Appeals opinion. And I want to start...
If Utah's statute was organized differently such that it included a separate section that was entitled landlord exemption, which permitted a person to claim a tax exemption, for example, each residential property he or she owned that is the primary residence of a tenant, would they be entitled to claim that exemption?
I think they would be entitled to claim that, and they would not be disqualified in this instance because it would be characteristically different. But in this case,
So what you're telling me is that it's not a substantially similar exemption; it's a substantially similar statutory framework. I'm
The-
having a problem with that.
The question is, I think, Justice Zara, whether or not it is a exemption that is based on a primary residence, a property being used as a primary residence. So I guess to clarify my earlier answer, really, the key here is it a homestead-based exemption? And we didn't cite it specifically in our briefs to this court, but we did to the Court of Appeals, to something Chief Justice McCormick referenced in the earlier argument about being a fan of restatements and corpus jurisprudence, et cetera. We cited the fact that if you look at the corpus jurisprudence about homestead exemptions can include tenant-occupied property as well as owner-occupied property. And so it doesn't change its character as a homestead exemption.
But our statute specifically uses the word principal residence exemption.
Correct, and that is the core of the exemption, is that it's principal residence based. And so Utah's also is primary residence based. So if you look at Michigan, MCL 211.7 CC sub 1, it says a principal residence is exempt. That's the core and the general essence of the exemption. Everything beyond that, in terms of defining, whether it's owner occupancy, which is not a strict rule in Michigan, or whether it's tenant occupancy or anything like that, that's a question of scope. It's a question of policy for the legislature. And in Michigan, when it comes to owner occupancy, Michigan has said, in some instances, we're okay with it not being owner occupied. So one example would be active military. Active military can still claim the exemption for up to 3 years, even though they are not occupying that property. Another example would be that there is a 3-year extension if you are not occupying the property, but you have moved to a new home and are owner occupying that property and have the other property up for sale. You can continue to have that exemption under subsection 5. So owner occupancy is not a strict rule. The Rentschler decision from the Michigan Court of Appeals also demonstrates that owner occupancy is not a strict rule, because in that instance they said, the fact that you were renting your property for more than, Treasury had a standard of 14 days, and the Court of Appeals said the fact that you were renting your property for more than 2 weeks is not going to change the fact that we view this as, still qualifying for the principal residence exemption. So it's not a strict rule. It's a matter of policy for states. And in order to provide flexibility, in order to account for the fact that all the 50 legislatures are going to experiment, are going to come to different conclusions, the legislature in Michigan adopted that broad character-based approach. And
But counsel, weren't they mostly concerned about everybody gets one home they get to live in and get the exemption? So I completely agree with your analysis. Michigan has a ton of snowbirds.
Sure.
A bunch of them don't want to pay income taxes, so they established residency in Florida where they don't have income tax. So they are now a Florida resident. To be that, I think it's more than 6 months a year, 6 months in a day, or whatever. So they have to be done in Florida. They're no longer a principal resident here. So we all get that that's like the traditional second home that they can't get it in both states. So that to me seems clear. If this case involved a home in Utah that, the ski house that is not rented out long-term, it's just a vacation home, obviously and Utah had, I guess that's the question, is if Utah had that vacation homes also get exemptions now. So that is the challenge of this case, right?
Yeah, no, absolutely. And I think that, it's appropriate to recognize that the principal factual application, a lot of times for this disqualifier, is the fact that you have somebody who has, 2 homes in 2 different states and they've got to choose. But that's not the test, right? And the fact of the matter is that under subsection 2 of 211.7 CC, when a person signs an affidavit, they're verifying 2 things. They're not just verifying that this is in fact their principal residence, but they're also verifying that they haven't claimed a substantially similar exemption elsewhere. And because those are 2 separate requirements, I think that shows the fact that, although policy-wise it's certainly tied together, it's not exclusive, and it's not the exclusive application of the test. But if I can get over to what Justice Kavanaugh had raised earlier in Ms. Stirling's argument about the layout of the Utah law, I think it's important to recognize that when the Stirlings are talking about two separate exemptions under Utah law, it's not accurate if you were to delete subsection 6 altogether, completely ignored subsection 6, you would have a residential-based exemption under subsection 3, which by the definition under section 102, and subsections have moved around while we've been litigating this case, but I think it's subsection 34 now, the definition for residential property. The core is that it's for any property used as a primary residence, which regulations define in Utah law as a domicile. So what you would have, because under the Dennis case, it says the crucial qualification is that the property is used by somebody as a principal residence, that it doesn't matter what subsection 6A and subsection 6B say. If those were out, altogether, a tenant-occupied property would still qualify because it would still be the primary residence of somebody. What subsection 6A does is it provides the general rule, similar to Michigan's rule, that you have one exemption per person. What subsection 6B does then is that it clarifies that limitation, and it says that that limitation doesn't apply to the extent that you also have a tenant-occupied property. So it permits, as Ms. Stirling was pointing out, that certain Utahns can obtain more than one exemption. But in Michigan, that's not the case. Michigan has a very strict one exemption claim, and so the policy
But
is.
that's why we're here.
Yeah.
That's why we're here. That's for us to decide, not for you to declare.
Well, I'm pointing out, Justice Zara, just that there is that one limitation claim throughout the text of 211.7cc that says that a couple is entitled to one exemption. And so I think the best way to effectuate that policy is
One principal residence.
one's principal residence exemption is that to the extent that an exemption is a primary residence-based exemption, it is a substantially similar exemption. And it's important to note that there are a lot of states out there that are similar to Utah. In fact, if you looked at, we cited in our brief a couple of those. We didn't do a full 50-state survey, but if we pointed out a few of those, one of those being Wisconsin. Wisconsin defines its exemption as, consistent with corpus jurisprudence, a homestead exemption, and that homestead exemption applies to tenant-occupied properties. Similarly, the Massachusetts legislature has adopted what it views as it calls Class 1 residential property, and Class 1 residential property means primary residential. Getting to the point that Justice Welch raised in terms of vacation properties, what would be substantially dissimilar, for instance, would be if you had, Gulf Coast states, Mississippi and Alabama decided that they want to boost their tourism industry, they want to compete with Florida, they're going to give an exemption for secondary residential property, for vacation homes. That would be substantially dissimilar. It would still be a residential property exemption, but it would not be a primary residential or principal residential exemption.
So if Utah said, we have certain properties that are used year-round, some in ski areas, and then people enjoy summer hiking, and they gave this exemption to rental properties that are not primary residence of a tenant, then they could use it.
Correct, because it would be a secondary residential property, and in Utah law, actually, and this was, I think, a very minor point that was referenced in our Court of Appeals briefing, there's actually forms that note that secondary residential property, and the previous tax tribunal decisions in Whiting and Boyd reference this, secondary residential property is a altogether different classification of property, and I think that's recognized across the board, nationwide. So that would be a different type of exemption, and it would not be subject to the disqualifier that we have here. This disqualifier is, as the Court of Appeals very carefully and aptly laid out, it is about the essence of an exemption, that it is a primary residence exemption.
So the primary residence exemption, the first part, I think 6A or 6B1, I can't recall which it is, that creates an exemption for living in a home in Utah. You would say that is exactly the Michigan exemption? And then the second provision for primary residence occupied by tenants is a substantially similar exemption. Is that your position?
We would say that, yes, to the extent that it's owner occupied, it is exactly, at least in the core sense, not obviously with respect to, you know, the number of dollars, et cetera, but in the core sense and the policy sense, it is exactly. And the other, we would say, it's substantially similar, but as a matter of Utah law, it is all one exemption, and it is all primary residence-based. I think, you know, getting back to that question, though, the big picture is, you know, the Court of Appeals, if you look at, you know, what are we talking about here? We have an equation, and an equation is A, squiggly line, you know, equal sign B, right? So it's A roughly equal to B. And the squiggly line has been defined by the Court of Appeals. It's not been disputed by the Stirlings that the test is what it is. Instead, we're talking about the application, A and B. And on the B side of things, you know, the question is simply, does owner occupancy matter? And our position is it's a homestead exemption, and homestead is what matters. On the A side of things, the question is, you know, is there a difference between sub 3 being the exemption, or, you know, are there different exemptions between tenant occupancy, owner occupancy? Our position is, number one, that
You
it's.
have 56 seconds. I want to just take you in a different direction
Sure.
while there's still time. Did the Court of Appeals err in failing to give some deference to the tax tribunal's interpretation of the statutes that they apply?
Absolutely not, and I'll say for two reasons. One is that any deference standard, any, you know, a respectful consideration, anything like that, is only applicable to an agency applying law that it administers. And in this instance, because the core question was Utah law, it wasn't about the law that it administers. I think Judge Murray identified that in a footnote. The second would be that ROVIS is simply not a deference standard. I didn't cite it, but I'd be happy to point the court to an article I wrote for the Michigan Bar Journal about a year and a half ago about the ROVIS standard. It's not a, you know, it's not a deference standard. It's about carefully considering what an agency does rather than about deferring to and committing this court's judgment to what an agency
Thank
does.
you.
Thank you.
Thank you, counsel. We used up your time the first time around. Your case will be submitted. Thank you very much.
Thank you.